5 real questions, 3 seasoned advisors. 5Q IQ Financial Power-Ups with Trajan Wealth starts right now. Welcome to 5Q IQ Financial Power-Ups from Trajan Wealth. I'm Jeff Jr. with fiduciary advisors Marty Bryant and Corbett Leduc. Also joining us today is Kent Phelps, who's an estate attorney and CEO of Trajan Estate. So Kent, welcome to the show.
Thank you. Glad to be here.
So today's focus, will my financial plan take care of them? Trusts versus wills, protecting kids from blowing money, blended family challenges, probate pitfalls, and most of all, making it easy for those that you love. If you've ever wondered what really happens next, send your questions to trajanwealth.com/5QIQ. So let's get into it. Our first listener wants clarity. Do I need a trust or is a will good enough? So let's go to Kent with that question.
Yeah, the answer to that question is really easy, actually, is do you want all of your financial stuff, all of your dirty laundry in your family, all of the potential disputes in your family after you pass away? Do you want all of that to be public record? If you do, then a will is great. Mm-hmm. If those kinds of things are not what you want, then you may want to look at something other than just a will.
So when you say public, what do you mean by public, and what does that exactly mean? Does it get like posted on the web, online or on a website, or?
Yeah, so a probate action, which is what happens if all you have is a will. A probate action is kind of like a civil lawsuit. And so that means that anybody can go down to the courthouse and comb the docket, find out who's involved and what the assets are, and what the points of contention are. And of course, now it's even easier because you can just go online, get that information. What we like to say is that whoever is doing this can use that information for either commercial or even nefarious purposes.
So wouldn't you think states would put protections in place, though, knowing this?
Yeah, and I guess those protections really are the laws that every state has that allow assets to transfer in a different way.
We know just enough to be dangerous for what we do. So the way I kind of explain it to people is that the trust is the belt or the wrapper for your durable documents, your last will and testament, your living will, financial and medical powers of attorneys. And then we re-record the deeds to your house, into the name of the trust. So it looks like you own nothing, but you control everything. And that's for me to play, steal from Rockefeller, right?
That's right.
But it sounds like it really does go even deeper than just that surface level.
Yeah. So let's back up a little bit, because when we say a trust, there are lots of different types of trusts out there, right? Mm-hmm. The type of trust that most of us need is called a revocable living trust. What does that mean? Revocable means after you create it, you can change it, right? Nothing is set in stone. Living trust means this trust is all about you during your lifetime. It's not about your kids. It's not about charities. It's all about you during your lifetime, meaning nothing changes in your life. You continue to pay your bills the same way you always have. You report your taxes the same way you always have. Mm-hmm. If you want to go to Vegas and blow the kids' inheritance, nobody can stop you from doing that.
I'm doing that now.
Yeah. Is that the advice you give your clients too?
No.
Yeah.
I want to keep their assets.
Yeah. So do as I say, not as I do.
Exactly.
Yeah.
Exactly.
No, and so that's the type of trust we're talking about. And then, right, Marty, I mean, you said it. The concept behind a trust is really simple. Don't own your stuff, okay? And you're right. J.D. Rockefeller said, own nothing, control everything. And so what this means is at the end of your life, you don't own your home. You don't own your rental properties. You don't own your investment accounts. Your trust does. Mm-hmm. And since you don't own anything at the end of your life, well, there is no estate to probate.
Yeah.
Mm-hmm.
That's a general concept.
So what's really the point of a will then? I mean, if it subjects all your assets to probate and it makes it public, it doesn't sound like it's doing much good of.
Yeah, so a will is going to do two primary things. Mm-hmm. Number one, it's going to identify who's in charge when you're gone, okay? The second thing it does is it identifies who gets what. So there are situations perhaps where somebody doesn't have a whole lot and they just want to identify, again, who's in charge and who does my stuff go to? And they are below what's called the probate exemption. And every state has an exemption.
Mm-hmm.
And some states have a very high exemption, like $300,000, as long as you're below that number in net worth and real estate value, then no probate is required.
Is that the same thing as a small estate affidavit kind of thing?
That's right. And so a small estate affidavit is a tool that we can use to avoid probate if you're below that exemption.
Okay.
There are other tools too, like beneficiary designations, for
Yeah.
example, right? But some states, the probate exemption is $30,000.
Mm-hmm.
Yep.
And so you got to know, based on what state you're in, which one applies to you. But here's one thing I'll add. Even in those situations where maybe probate is not a concern, but maybe they have a child with special needs.
Yeah.
And that child is receiving government benefits.
Right.
And the will is going to say, well, when that child turns 18, then they get the money. Well, when they get the money, they may be disqualified from those benefits.
Yep.
So even in, we'll say, low net worth situations, there still may be a reason why we don't want to have a will.
Mm-hmm.
Mm-hmm.
So then I know nowadays, we have something called gray divorce. That's people a higher, the people who are 50 years and older, we're seeing a lot more divorces happening. 50, 50 plus. We call that the gray divorce.
That would be me.
That would be you. You are 50 plus, so am I. So with those people, we're seeing that sometimes they try to keep their assets separate in title, but their assets are commingled in life. How can you take care of that through the estate planning process?
Yeah, so your scenario is post-divorce and then a remarriage.
Correct.
Right? Okay. All right. So yeah, it's very common in that situation to have a his trust that has his separate property in it that's going to go to his kids, typically, if she has sufficient assets that she doesn't need to be supported by his assets. We have a his trust. We have a hers trust, does the same thing on her side, keeps everything separate. And then sometimes, especially if they're fairly early in life, like in their 50s, very likely that they will build some stuff together, right? So we have an ours trust.
Okay.
Now that feels very self-serving from an estate planning attorney's standpoint, right? 3 trusts, great. But no, sometimes the clients just seeing the relief on their faces when they realize, okay, I can keep my stuff separate. I can protect my children, but I love my new spouse and I want to treat this like a joint marriage. Well, guess what? We can build stuff together too, but protect the stuff that's separate.
Okay.
Now, how is that separate from like subtrusts?
Well, subtrusts happen post-death.
Okay.
Yeah. And so if we want to talk about that really quick, basically with a trust, when we die, the trust can then operate in one of 2 ways. The first way is the simplest way. We call it outright distributions. And all that means is that, okay, and again, all this is happening outside of court, right? And, there's some administrative work that has to be done. We've got to pay the last expenses and file the last tax return and liquidate assets. And after all of that administrative work is done, with outright distributions, we just cut checks to the kids and grandkids if they were included, and we shut the trust down. The trust goes away. The children ride off into the sunset with their inheritance, and we're done. So the upside option, this simpler option, outright distributions, is that it's very simple and straightforward to administer after someone dies. The downside is that, once again, if we have a child who is in a situation, and again, maybe we have a disability, well, if it's outright distributions, they're going to get disqualified from their benefits. Maybe after you pass away, they're in a car accident and it's their fault, and they don't have enough insurance to cover the brain surgeon's damages whose career they ruined, heaven forbid.
Right.
And they end up with a personal judgment against them. Well, with outright distributions, that creditor can take the inheritance away. So now going to Corbin's question about subtrusts. So that's the other way we can structure a trust is we can actually keep the trust going. And instead of a child receiving a check, they receive a trust in their name that if they're old enough and they're and they're qualified enough, they have a good head on their shoulders, well, they are in charge of their own subtrust, and they can invest in any category of asset they want to in the subtrust. And if they want a distribution, to buy a car or take their family to Disney World, well, then great. They can just make that distribution and immediately consume it. But everything they don't need stays safe inside of the subtrust. Now, if that creditor comes knocking or they go through a nasty divorce, pick your crisis event, that creditor, that ex-spouse cannot touch what's inside of the subtrust they inherited from mom and dad.
So it's a good way to protect the kids.
It is.
Even after you're long
Right.
gone, where they just don't get a check.
That's right, and promote generational wealth too, if that's if that's an objective.
But I think
Well, and sorry to interrupt, but speaking of generational wealth, I think, and I'm just going to be self-serving for us.
you self-serving?
I mean, for us, it's you too. You
Okay. Oh,
too.
thank you.
As an advisor, I feel that it's extremely important for an advisor to be involved if there are invested assets, because when somebody passes away, whether it is just a direct distribution or not, that way we can give the beneficiaries the opportunity to get the step up in basis on stock, highly appreciated stock, and keep it invested, have them inherit it at the current value as of the date of death, and leave them invested, because attorneys aren't financial people. If you're going to do a direct distribution, your goal is, hey, liquidate, boom, here's a check.
Right.
But when you involve a financial advisor in these scenarios, now we can advise from our expertise that was going to complement your expertise.
Well, no, on top of that, there may be addiction issues. There may be spendthrift issues, because the example I give in my meetings when I'm talking about estate planning is that if a cement truck took me out on the way home, as much as I love my son who's 19 years old, I know that before my body is cold, if I didn't have a properly structured trust, there would be a brand new Porsche GT3 in the driveway, and my son's logic would be, well, my dad want me to be happy. Totally. Below 350 grand on a car,
That's right.
and probably 30 grand a year on insurance. Yeah, that's exactly why I work so hard.
We'll get to kids here in just a second, but I think the original question was, will a will be enough? And I think we've determined really a
No.
will isn't enough. Just make sure that you understand the probate exemption in your state. As a general rule of thumb at Trajan Estate, we say 100,000. So if you have 100,000 in assets, which also includes equity in your home, you should probably have a properly structured trust, so you don't have to go through all the issues with probate and family conflict.
It's a good rule of thumb.
So next up, the question every parent quietly asks about inheritance. If you've ever wondered what your kids would actually do with the money, like Corbett's son, send your questions to TrajanWealth.com/5QIQ. You've got the will or trust figured out, but now the real worry hits. How do I make sure my kids don't blow the money? Our listener asks, how do I take care of my spouse and protect my kids? So let's take that question to Kent, who is the CEO of Trajan Estate.
Yeah, I guess they're two very different questions. So I'll answer the question about how do I take care of my spouse first. And yeah, let's talk about it within the context specifically of a blended family. Is that
Sure,
to
yeah,
focus
let's
on that?
focus there.
Blended family planning is one of the most difficult things to do in estate planning, because we have competing objectives, right? Especially if it ends up being a long-term second marriage, then typically the objective at the end of, let's say, the husband's life, is if he passes first, is to make sure that his spouse is taken care of. Now, the way that we do that typically is that there would be a joint trust in a long-term second marriage situation. And that joint trust says that when husband passes away, then the spouse now is in full control of everything. And the spouse can utilize the money for his or her benefit the way that they want to, without having to answer to the children. And I'm talking about this again as if it were a long-term second marriage, okay? Because if it's a short-term second marriage, we may do something different. But long-term second marriage, typically what my clients want, and that's what drives this, right, is what does the client want? Typically, they want to make sure that their spouse would have, no conditions, let's say, that they can use the money the way that they want to. Now, but let's say that we have a more unique situation where there is a concern that if we set it up that way, that the spouse is going to blow through everything or might redirect assets over to her children, right? And disinherit his children.
Right.
So the way that we do that, we got a number of tools in our tool belt, and some are more user-friendly, I'll say, than others. One of the more user-friendly tools that we use is called a contract to make an estate plan, believe it or not. And this is, we'll call it kind of a side agreement to a trust. And it says, all right, so when one of us passes away, we are agreeing by contract. And by the way, most states have a statute that specifically says these are enforceable, okay? So this isn't a willy-nilly thing that the attorney makes up. And it says if one of us passes away, then the surviving spouse does have full control over everything, but may not change the beneficiaries of the trust, may not change beneficiaries on IRAs or 401ks, and that if it looks like the surviving spouse is doing something that is in contravention of the spirit of this agreement, the children have legal remedies to stop him or her from doing that.
Who enforces that, Kent?
It'd be the children. The children
okay.
of the deceased spouse, right? Yeah.
So how frivolous can they get, though? Can it be as frivolous as, we think Martha really is, spending all the money? Let's look into it.
I'll say we address that situation with more complex tools.
Okay.
This tool, again, is simple, and all we're saying is that Martha can't change the beneficiaries of the trust.
Okay.
She can't change the beneficiaries of the IRA to her kids.
But the trust can say Martha can only spend X amount per year.
That's right. So let's talk about a more complex tool. A more complex tool, sometimes referred to as AB trust planning, or survivors trust and decedents trust planning, or credit shelter planning. And what this means is that we're going to set aside a portion of the estate, usually around half, that we are going to put into an irrevocable trust. All right, meaning that the surviving spouse now cannot change it at all, even without a contract to make an estate plan. She can't change it, and there are rules about how much of the income or principal she can use.
I've seen those.
Yeah. As it says, typically is that she has an absolute right to income. Okay, that's typical. But if she wants to invade principal, then the trust is often set up so that she has to get the permission of the deceased spouse's children to invade principal.
Is that the 5% rule, or?
Well, that's a little different, but yeah.
So I have a question. Do you have to put language in there? Because I know that trust laws change within different states, right? They change rules, I should say. So let's say that there's an older one and it hasn't been modified, an older trust. Yeah, not older like you. But, and can it be modified to can it adjust for inflation? Or let's say that, they can live off income but not principal, but let's say that income is not enough to live off of after inflation takes over and all of that.
Well, that's why the trust would say that principal can be invaded.
Okay.
Right.
Okay.
But we're going to get the permission of what we call the remainder beneficiaries, right? His children, to sign off on that. Now, can that create conflict? Yeah.
Sure.
It can. And so that's a price we pay for setting up a plan like that.
Yeah.
Is we could be, now, of course, the trust is going to say, well, we can't sue each other because if you sue, you're out.
I think the point is, regardless of how messy your family situation, how many marriages, how many kids with whom, et cetera, it can all be settled legally,
right,
professionally,
yes,
avoiding probate, avoiding further family conflict by having a properly structured trust.
Yeah.
After this break, probate reality and the one question that makes this planning feel all very worthwhile. If you have an estate question for us, don't hesitate to email us at trajanwealth.com/5QIQ. Now, you've heard the word probate, but most people don't know what it actually means for their family. So what is probate, and should I avoid it? So let's discuss what probate is.
What probate is.
What is probate?
What it is.
Why do I want to avoid it?
Well, there's a great quote out there. Probate is a lawsuit you file against yourself for the benefit of your creditors.
Doesn't sound like too much fun.
Yeah, and there's truth to that, right? Meaning that a probate action can be very similar to a civil lawsuit. Similar rules of discovery and evidence um, and court process apply in a probate action as apply in a civil lawsuit.
And costs.
And there we go. And so it's public. There are studies that are done out there, and AARP says the average probate's taking about 18 months to resolve. I think that's pretty accurate, actually. But we've been involved in probates lasting as long as 5 to 6 years. So you never know. If you take the value of your estate, you multiply that by about 5%, that'll tell you about what your heirs will spend on probate. And I had a recent client who actually said, okay, so yeah, mom's estate was worth this. We spent $150,000 on attorneys. By golly, that's about 5%. And so those are good rules of thumb. But what probate is ultimately is, think about it this way, before civilized society, if you will, when someone died, who got the dead person's stuff? The fastest, the strongest, right? And so we've had to develop a civilized way by which property of a deceased person passes to whoever is entitled to it. And that's what probate is for. So probate is a very good thing conceptually, right? Because there is a process for the transfer of assets from a deceased person to whoever is entitled to it. But in order to get there, we have to do some things. Number one, the will, if there is a will, has to be admitted to the probate court, and the court has to review and authenticate the will. Public notice has to be given, even nowadays, typically in a newspaper, believe it or not, that number one, you've passed away. Number two, a probate has been opened in your name. And number three, anyone who wants to stake a claim against your estate has a certain period of time to do so.
Anyone.
And it has to be all done in the newspaper?
Yeah.
Wow.
Yeah.
This is 1890 or?
Exactly. Yeah. It is most often still done in a newspaper. It varies from county to county,
Right.
but that's typically how it's done, even now. And so what you're doing is you're inviting people and entities, creditors, to come out of the woodwork and stake a claim.
Yeah, so probate in theory is a good thing because it maintains order,
Right.
but you want to avoid probate really at all cost,
Well,
because
again, if these things are important to you, if privacy is not important to you, if the cost is not important to you, if
Right.
delay is not important to you, then go through probate.
right.
Well, we have clients that say, "Oh, what do I care? I'm dead." But then, we have to bring up the fact that, well, you still have stuff left over,
Right.
and you do want that to stay within your family, I would assume.
Over decades of practice, I've come up with an answer to that question or comment that clients make that, well, I'm going to be dead, so I really don't care. I said, okay, well, so maybe you don't care about what happens to your children after you pass away, but do you care who they become?
Ooh, that's good.
Yeah.
Because typically probate invites conflict. And
Yep.
if there's one lesson I've learned over the years, it is that death and money change people, even under the best of family circumstances.
100%.
Unfortunately. Yeah.
100%.
Oh,
Sure.
yeah.
Yeah.
Yep.
Yeah.
Yep.
No.
Yeah.
No.
So let's close the question that turns all of this planning from obligation to gift. How do we make the estate transfer easier for my family? The question might be. So if you want your loved ones supported without the stress and the confusion, this is your answer. So let's discuss that one.
And so we're talking about just transferring assets to the children easily,
How do we
or
make it
or
easy?
to
What's
whoever.
the
How
most
do we make it
easiest
easy?
We've answered that pretty well thus far.
Yeah, we've talked about that somewhat, but no, I've got some comments to make on that. Number one is, if you are thinking about disinheriting one of your heirs, think really hard about that. And there might be really good reasons for doing that. But number one, think really hard about that, because even though trusts can nip lawsuits in the bud, right, and keep them from going very far, we can't prevent someone from going down to the courthouse and filing a lawsuit. We can't prevent them from doing
Right.
that,
Even if you have a trust set up.
even if you have a trust set up. We cannot prevent that. And so try to promote family unity, I guess, and to provide for everybody. But in terms of the actual transfer of assets, it's just really about clarity, making it very clear on your IRA that all of my stuff goes to my trust. And then in the trust, you say, well, everything is divided equally between my children. And
Can I interrupt you on
yeah,
that really
please.
quick though?
Yeah.
So, and I want you to I want you to clarify this. Not all trusts allow for the passing of an IRA or a retirement account straight through.
Yeah.
It has to have specific language, correct?
It does. So there's a principle out there, and it is that all trusts are not created equal, right? And there are, I'll say, about 3 different levels of trust when it comes to IRA planning. One level, the lowest level, is that it just can't handle IRA money, and if the trust is named as the beneficiary on an IRA, then basically what's going to happen, it's going to bypass the trust and just go to the individual, and we may have to work that out even through probate court maybe. Level 2 is that, okay, so the trust is engineered to receive IRA distributions, but the trust is not so sophisticated that it allows us to accumulate those distributions, those RMDs, right, required minimum distributions, inside of the trust without creating a very high tax bracket, right? About 37% is the trust tax bracket. And so with the level 2, then the RMDs have to flow through the trust and then to the individual. So, what benefit are we getting there in terms of protections? Not a whole lot.
Right.
The highest level of planning for a trust, we have our cake and eat it too. Number 1, the trust is an IRA qualified trust. It can be a beneficiary. Number 2, the RMDs can come into the trust and stay in the trust, but be taxed at the beneficiary's individual tax bracket.
Yep. Yeah. I have, my aunt passed away last year, and I'm the successor trustee, so it's my first personal experience of settling an estate, and she had a trust, and it's still difficult. And I'm in the industry, and it's been a pain in the
How long have it been going for?
badonk-a-donk. Well, it had been restated 5 times. There was some of the one of the issues that I had, and I had to consult with the attorney on, is that there was a spendthrift provision in there for one of the beneficiaries, and it said she cannot have a direct distribution. There was no subtrust for anyone, but she could not have a direct distribution. She was only allowed to get monthly payments, no lump sums, and he said it for a specific period of time, but vehicles like that don't exist. So he wanted guaranteed, right? A guaranteed income stream, but that vehicle did not exist. So I had to consult with, because the CARES Act, there's no stretch on these inherited IRAs, right? So I had to consult with the attorney, and she said that I do have leniency. I can do what is in the best interest of the trust and the intended language, which made it much easier for how I'm distributing the assets for her.
I'm going to take a wild guess. You were the beneficiary that was blocked from getting a lump sum.
Yes. Dang it.
Good conversation. I think the big point that I took out of that is not all trusts are created equal.
Right.
It's you can go online and get a cheap trust, but is it actually going to do what you intend it to do?
Right.
Exactly.
And the answer is probably not.
Cheap is not good, and good is not cheap.
Yeah. So
And intention doesn't, trump the law.
Right.
So the best question is, will it solve the problems I have? First and foremost, not what is the cost. So what questions do you need answered next? Tell us now at trajanwealth.com/5QIQ. So share this episode with someone who's nervous about estate planning. It'll benefit them and it'll benefit you. Plan smarter, dream bigger. One clear step forward today? Well, that's the win that we're after. So thanks for joining 5QIQ Financial Power-Ups with Trajan Wealth. We appreciate your time, and we will see you next week.
Trajan Wealth, an SEC-registered investment advisor. Additional services through Trajan Estate and Trajan Tax. Information discussed during this program is intended for illustrative and entertainment purposes and is not investment advice or an offer to buy or sell any investment. Please consult your financial advisor for questions about your financial situation. All investments involve risk and the potential for loss. Any examples given are strictly hypothetical. Your results may vary. Additional disclosures at trajanwealth.com.